Good morning, students. Today we'll start with the concept of delegated legislation. Now, before we start with the concept of delegated legislation, as always, I would be raising certain questions in the current context. Delegated legislation is an essential reading today for the simple reason that of late we have been observing a lot of delegated legislations in the context of COVID-19. The Maharashtra government has come up with a notification, COVID-19, the Epidemic Diseases Act 1897 lockdown order. Then Delhi and Karnataka have come up with epidemic diseases COVID-19 regulations. So different state governments are going ahead with their own ways of handling the situation which has been created by this particular virus. But almost all are being handled by some or the other sort of delegated legislation. Now, since you are reading these names, notifications, directions, rules, you need to understand what it is. They are all delegated legislations, which means they are legislations by an authority other than the legislature. So all of them, the rules, orders, notifications, bylaws, circulars, all of them issued by executive authorities come under delegated legislation. Now, what is a rule? Rule is a general norm under a particular act, whereas regulation is a specific norm under the act which is more controlling in nature. Bylaws could be regulations made by a local authority or corporation, for example, bylaws of a housing society. Then circulars are the internal memos which provide for clarification on certain issues or a written statement of government policy. They are generally issued by some ministry or by some department. Whereas when you hear of notifications, these are public notifications in official gazette on the existing provisions of any act in exercise of certain powers which are derived by that particular legislative enactment or a provision of it. There's one more word which is being used, and that is guidelines. What are these guidelines? They are issued by organization, which could be government or private, to make the actions of employees more predictable in any set of circumstances. So these are different kind of delegated legislations. But here there is one thing which you need to understand as a key word, and that is it is authority other than legislature. And these are generally executive in nature. So it means the exercise of power of rule making by executive under the authority delegated to it by legislature and its outputs. So when I am talking about outputs, I am talking about these kinds. Now there's one more thing which you need to understand here only, that delegated legislation is different from executive legislation. And please don't confuse it with executive legislation. Delegated legislation stands for laws which are made by authorities other than legislative bodies. And this work is delegated to them by the legislature. Whereas when it comes to executive legislation, there we are talking about the powers of president or governor under Article 123 and 213 of Constitution of India. So that could be in the form of an ordinance. That is what is issued in between the parliamentary sessions. So this thing has to be kept in mind. There's no scope of confusion here. Now there's one more thing, that this kind of activity has increased a lot in recent times. Now what could be the possible reasons for such an enormous increase in recent times? Now, if you look at what has been stated by MP Jain when it comes to delegated legislation, he says that it is a term which is used in two different senses: to exercise the legislative power by the subordinate agents, or the subsidiary rules themselves which are made by subordinate authority in pursuance of the power conferred to it by legislature. That is how he has explained the legislation. Now there are very clear reasons for growth of delegated legislation in today's context. Number one, we are a welfare state now. Now when I'm talking about welfare state, please get back to what I taught you earlier when it comes to nature of state. There were earlier three traditional functions of the state, and they were defense, taxation, and administration of justice. Things have gone much, much ahead of the times when the state had only these three functions. Now the state has entered into lot of areas, and almost every aspect of our life is covered by some or the other legislation. There's some or the other regulating body. There's some or the other way in which state is supporting us. So all this requires some kind of norm. Now can we get back to parliament for every single thing? Parliament is there in session only twice a year. And how many legislations can they come up with? So the easier way is to delegate the authority to people who are more closer to the ground, who know things better, and who would be able to handle things better. That is the reason why in welfare state, the need for delegated legislation has increased multifold number of times. Then there could be certain areas of very technical nature. See, we need to understand one thing. These parliamentarians who have been elected by us are generally generalists, not specialists. When I say generalist, what I mean is they have studied the general courses. When I say specialist, I mean a person who has studied a particular branch of knowledge and who is expert of it. So out of all the people who are there in parliament, who can be rated as a specialist? Almost all of them are generalists. Their degrees are general in nature. So if I expect them to come up with a norm relating to, for example, atomic energy, can they do it all by themselves? Because topics like atomic energy, or for that matter gas or electricity, require specific knowledge. If you don't have specific knowledge in hand, how would you come up with norms? That is the reason why when it comes to areas of excessively technical nature, this work is given as a part, given as delegated legislation. Then there could be certain unforeseen circumstances. When I say unforeseen circumstances, it could be anything. It could be something which was not presumed earlier. It could be circumstances, for example, the current one, that is spread of COVID-19. Then how to handle these circumstances? Or it could be war, it could be economic depression. Then if we depend fully on parliament, then we'll have to wait, because the parliament is currently not in session. We'll have to wait till summer for government to come up with norms. When it comes to ordinances also, there could be excessive pressure. Now see the situation, how easily it is being handled because of delegated legislation. Every state is coming up with norms according to their circumstances. They're handling. One is coming up with notification, then there are states who are coming up with the regulations, because regulations can be specific. So the situation is being handled, and they are able to handle it as per the threat which they are perceiving. So this is how delegated legislation can aid you in extreme circumstances which cannot be foreseen earlier. Any set of parliamentarians, however wise they cannot predict this. Then, flexibility. There is so much of flexibility which the delegated legislation gives to you. You can handle any set of circumstances. Why? Because the delegated legislation is far easy. You don't need to go through the periods of so many discussions to be able to handle it. So flexibility is one aspect. Emergencies, whatever circumstances come our way, they are handled. Then there are certain areas which require specific experimentation, where experimentation can be done. Generally, the example of traffic, the road traffic norms is taken here. Why? Because we can come up with a particular norm and see how effectively it is being implemented, or whether we should be implementing it at a mass scale, or we should take it back. All these things, these studies can be done if we have a delegated legislation in hand, wherein we would come up with norms, and if they are not working properly, then we can take back the norms. Then there's one more reason, and that is the complex modern administration. As I said, the current administration is not as simple as it was there earlier, which means we are handling many kinds of things. Now, similar to the fact that we are handling many kinds of things is the fact that there are so many set of people who could be involved. You could be looking after employment, you could be looking after trade, education. The complexity is such that the nature of the required legislation could be excessively interdisciplinary. All these things, the specifically the socio-economic policies, can be handled really well by delegated legislations. Now these are some of the reasons why it is said that delegated legislations are on rise. Now see, when there are so many advantages, specifically in current context, you would look at advantages only, because the norms are coming up very fast as per the requirements. There are certain disadvantages also, and we need to look at them. Number one, it is inherently undemocratic in nature. See, we chose our representatives for parliament, and these people who are coming up with these with the delegated legislations might not be the chosen representatives, and all our chosen representatives are yet to hold a discussion about things. So that way, a lot of scholars find it inherently undemocratic. Then the information issue. Public might be very uninformed when the things start. For example, in today's context only, the borders got sealed, but still there were so many people who wanted to go from Delhi to Noida, so many people who wanted to come from Noida to Delhi. they were not aware of the fact that borders are sealed now, because these norms simply come out of thin air. People might not be so informed about it, and they are just implemented on them. See, these steps are being taken by executives by way of norms, one by one. And by the time public gets to know of the things, it could be really late. Then proper scrutiny is very difficult due to sheer quantity. See, try to understand, we are talking about quantity. So many norms are coming up in current context also, and things are changing every day. So if today I am required to comment on what is the normative position when it comes to COVID-19, I'll have to ask for some time, look into my notes, look here and there, do some net searching to find out if a new norm has come or not. And see the sheer quantity. Every state is coming up with its own norms, and they're changing frequently. So these are certain disadvantages. But when they have so many disadvantages, there are certain safeguards also, which means there is certain control also. So whether you are asked about safeguards against delegated legislation, or you are asked about the control over delegated legislation, we mean the same thing. Now there are three kinds of controls which are exercised. First is procedural control, second is parliamentary control, and the third is judicial control. Now when it comes to procedural control, we need to understand that the procedure which is being followed when it comes to delegated legislation has to satisfy certain criteria. Not that they can do anything and everything and not follow any norms, any procedure. So certain procedural safeguards are there, and this is done to keep a watch over the exercise of power by executive and administrative authorities. Otherwise, they would be able to handle things their own way, something which cannot be allowed in a welfare state. Now the methods of control could be prior consultation of interests which are likely to be affected by proposed delegated legislation. Now what we do in this is we talk to people who are getting affected by the legislation. This is done more in countries like USA, wherein, for example, if you want to come up with a norm which would affect the medical practitioners, you will have to talk to their body. So for example, there is American Medical Association, then there are different boards. So you need to talk to them, you need to inform them that we want to come up with a particular kind of delegated legislation, see whether whether their opinion is in favor of it or not. Now this prior consultation is slightly weak when it comes to India. There are of course certain groupings which are very powerful, but for example the Chamber of Commerce, they are very strong grouping and they affect the courses of delegated legislation. But then these are little examples here and there. You cannot say that it has become a very well established norm in our country. Then the second way out is prior publicity of proposed rules and regulations. Now as such, it has never been stated that it is to be done, but prior publication seems to be a necessity under Section 23 of General Clauses Act. And Section 2 of Statutory Instruments Act also makes it mandatory that the statute must be published as soon as it is laid before the House of Parliament. So, as such, there is no strong provision. But then the judiciary has had a fondness for this norm, and that is the reason why it was discussed in this case, Haria versus State of Rajasthan, wherein it was clearly stated that we need to have something called prior publicity, which would be helping us more when it comes to delegated legislations. Then there's one more method, and that is the publication of delegated legislation. We can very safely say that this part is taken very seriously in India, because whatever is the legislation, it has to be published and due care has to be taken. And again, it has been stated by the courts that to follow this is equivalent to following natural justice. If you do not publish the delegated legislation, you are certainly going against the norms of natural justice. For example, in this case, Raza Buland's Sugar Company versus Rampur Municipality, what really happened was there was a statutory provision regarding requiring publication of rules before imposition of tax. Now, it was held by the courts that this is mandatory, which means you need to go ahead with publication. But how you go ahead with publication is something for which they said that that is for us to decide how it has to go ahead with it, which means it is directory in nature. But at least they said that publication is mandatory. So that is how publication of delegated legislation is as good as a very strongly established norm in our country. Prior publicity is laying its strong foot, prior consultation is weaker. Then the next is the parliamentary control. See, there are ways in which this is also exercised. In the sense, there could be proceedings in parliament, there could be an offending provision which is to be laid on the table of the legislature, and of course there are scrutiny committees. Now, what we really do in this is, number one, we lay the delegated legislation before the parliament. There are so many acts in which it is clearly stated that rules and regulations are to be laid before the parliament. So this requires a higher level of scrutiny when you ask for laying before the parliament. Now, when it is done, the members of parliament get an opportunity to discuss it, and wherever they are finding things not permissible, they can ask for amendments. Then the offending provision can be laid to the table of legislature. That is, when there is an issue regarding a particular thing, it can be handled. Then you have parliamentary control through scrutiny committees. Now here I would specifically like to mention that in India this is comparatively very stronger a thing, because we have a Lok Sabha committee and a Rajya Sabha committee also. The Lok Sabha committee for subordinate legislation came earlier. It came in 1953, and the Rajya Sabha committee on subordinate legislations came in existence in the year 1964. After this we have judicial control. Now this is also a very interesting aspect when it comes to delegated legislation. See, number one, the key concepts when it comes to judicial control is treat it parallelly to any other norm. Delegated legislation is not a special thing. So it has to be in consonance with Constitution of India. Like any other law, Number two, because it is a delegated legislation, it has to be in the four corners of the Parent Act. Now, when I say the Parent Act, I mean the act under which this legislation has come up. For example, in current context of COVID-19, the Parent Act is the Epidemic Diseases Act 1897. So whatever notification, whatever regulation the government is issuing, they need to first see what is the spirit of the Epidemic Diseases Act. That cannot be violated. So there is a twofold test. Number one, it has to be in consonance with the Constitution. Number two, it has to be in consonance with the Parent Act. Now, I hope these two things are clear. Then we have certain case laws which are very interesting in this current context. First is the INRI Delhi Laws Act. Now here it was very clearly stated that laying down of policy and enacting the policy cannot be delegated. So whenever we are trying something, we need to at least come up with principles which afford guidance to the subordinate body. The subordinate body is not expected to come up with the principles. They are expected to follow the principles. If we just leave everything on them, that is, they need to understand, they need to evolve principles, they need to evolve norms, then it is incorrect. Now, the reason why they came up with this kind of analysis was, here the Enabling Act itself exceeded the constitutional limits because it permitted the executive to repeal a law which was already existing. So this was something which was disliked, and it was clearly stated that the function of laying down of policy and enacting that policy cannot be delegated. But then one thing was also stated, that once a policy has been laid down by the legislature and the standards are clearly stated by a particular legislation, then the executive can be given power to come up with delegated legislation or subordinate rules within the limit of that particular act, and it has to be constitutional in nature. So these are some things which came up in this particular case law, and they are very essential when we do the readings about delegated legislation. Then we have one of our favorite cases, Air India versus Nargesh Mirza. Remember reading this as a part of Article 14 of the Constitution. This is landmark judgment in which a particular delegated legislation was struck down. See, initially only I stated that delegated legislation has to be in consonance with Constitution. Now this legislation was found not to be in consonance with Article 14 of Constitution. That is ultra vires the Article 14 of the Constitution. So just to get back to the things which were studied by you earlier, the regulation provided that the services of air hostesses would be terminated if they marry within first 4 years of service and on their first pregnancy. Now the court found these conditions reasonable, and that is the reason why it was struck down. And if you remember, it was also stated that to tell a woman not to bear children is an open insult to Indian womanhood. This cannot be done. It was found as violative of Article 14 of the Constitution of India. Then you have the famous case of Maneka Gandhi versus Union of India. Once again it was reiterated that any delegated legislation can be challenged on the grounds of Article 14. And it was clearly stated that any kind of administrative rule making can be challenged on the ground of unreasonableness within the purview of Article 14. Then there is one more interesting case which relates to Payment of Bonus Act, and that is Jalan Trading Corporation versus Mill Mazdoor Sabha. Now, insofar as this particular case law is concerned, the constitutional validity of Section 37 of Payment of Bonus Act was challenged, and the court declared it to be ultra vires on the grounds of excessive delegation, and it was stated that it is the work of legislature to remove difficulties and doubts. Now, if you have read a few acts, you must have seen that there is always a removal of difficulty clause towards the end of an act, which means it has to be done by Parliament only. So it was stated that it is for the legislature to remove doubts and difficulties in giving effect to the provisions of the Act, and this power of removal of doubts and difficulties which can result into altering of a particular Act cannot be given to subordinate authorities. So that is how it was found to be against